Turtleboy this week, they got to argue the megamotion that Turtleboy's attorney, Mark Bederow, drafted. And I don't really need to show you the court video because it's summed up afterwards really, really well. So what I'm going to play for you is the debrief outside of the courthouse. And it looks like this is Justice Served TV. So this is Michel Bryant, who is going to be interviewing.
Okay.
Let me bring it up.
Decide what to do. They're fact finders. They are there to determine whether there's probable cause to believe a crime was committed. It's a safeguard. The grand jury is every bit as much as designed to prevent false or improper charges from being brought as much as rubber stamping indictments for prosecutors. They have every right to seek indictments and present evidence as they see fit in support of an indictment, but they have to do it fairly. They have to do it with integrity, and a prosecutor, I mean, I've put hundreds of cases as a prosecutor in a grand jury. You have a duty of fair dealing. You are the legal advisor to the grand jury. There's no judge. There's no one there. And if you have a prosecutor who runs roughshod over a defendant's rights in a grand jury, you get situations like this where you have a prosecutor instructing the grand jury that his opinion and the lead detective's opinion is that a particular target had the intent to commit a crime. You can't do that. You can't present uncharged crimes and not give what are called curative instructions, telling a grand jury to disregard that. The answer isn't, well, we didn't seek an indictment, so who cares if the grand jury heard that you committed another crime that may be punishable by up to 5 years imprisonment. There is no world in any grand jury in any state in this nation in which that is appropriate. And that's just the beginning. You don't rename videos. You tell the grand jury, these are the videos, and the grand jury will do whatever they're going to do. They'll indict or they won't. But you can't put your finger on the scales. You don't change the names. You don't tell them someone's intent. You don't tell them the opinion of intent. You don't charge somebody with all of these crimes in this so-called rolling rally and have a soup to nuts A to Z video of the rolling rally and not give that to the grand jury, except to clip 50 seconds out of it and say, don't feel bad for the O'Keefes. This came from the intent folder. And by the way, he's not charged with any crimes against the O'Keefes, but this is how we're going to finish the case. That's not what prosecutors do. And whatever the ruling of this case will be, if the judge believes some of these issues were waived, he will do whatever he will do. But don't think for a second there is any world in which the conduct of the prosecutor and the lead detective before this grand jury was proper. It was the exact opposite of proper.
Let's go back to the very beginning. This was filed September 27th. Is there any possibility that the judge heard anything today that could affect what he already knew coming into today?
I don't know. I mean, that's up to the judge. You could ask lawyers about whether oral arguments in anything ever impact courts. I mean, the papers are there. The case law is the case law. I don't want to speculate what the judge is thinking. He's very inquisitive, as you know, and he was the last time. He was this time. And, as lawyers, you expect that. And that's part of what it is. Judges have questions. You answer them as best you can.
Judge seemed to really zero in on the high standard for a renewed motion to dismiss. But if I'm correct, Mr. Bederow, you didn't have access to a lot of this material when you filed your first motion to dismiss.
We did not have access to a lot of discoverable material that we believe would have been relevant to some of the grand jury proceedings. We didn't have other discoverable material, which is just generally relevant to the defense. And so the argument on top of how it would impact the grand jury is that we're going to file a motion to dismiss anyway for other reasons. There's no prejudice to the prosecution in adding on some of this. As far as the waiver issue or whatnot, if you go back and read the initial decision by Judge Doolin in this case, it was a thoughtful decision. It was a long decision, but he didn't know either. I mean, that's kind of the point, is that everyone was bamboozled by the way they did this. And at the end of the day, there's no prejudice to the prosecution in this. And when we talk about, not choosing form over substance, that's what we mean. This grand jury indictment is flawed. It's awful. It's not how prosecutors are supposed to indict people they believe have committed crimes. And, we can either just rubber stamp it and say it doesn't matter, or dismiss it, which is what is appropriate.
The judge did ask Mr. Cosgrove, well, why not just give him everything? Were you satisfied with his answer?
Well, no. I believe the answer was let him ask for it. But how do you ask for what you don't know exists because you're being misled on what it exists? You're being played clips of videos that are mislabeled. You're not told that there are 2 hours. Again, I hate to go on my own experience and anyone else who's a prosecutor. It's very simple. If you want to play a clip, you introduce the actual exhibit. This is the video of his show from whenever, and this is what it's titled. And the title would be, the rally for justice for John O'Keefe and Karen Reed, not don't feel sorry for the O'Keefes. If you play 58 seconds of the clip, then you say, I'm playing timestamp this to this of a video, and you introduce the whole video and you let the grand jury look at it. Now, if you don't want to play 17 hours of video, okay, but it's the grand jury as the fact finder. They have a right to know it. And the point that was being made is, if more of this video was available, or if they were doing this as honest brokers, you would have realized that intent can be.
So do you understand what they're talking about right now?
I think so.
So in the grand jury, what the defense is saying is Kate Peter took some of Turtleboy's videos and made clips out of them that are particularly damning, right?
Yeah.
So if I were to say, oh my God, I hate you, but I'm just kidding. I wish you no harm.
Yeah.
They would clip that to just be like, oh my God, I hate you.
Yeah.
So one of the big things that they have to prove is intent, what his intention was in saying these things. And they have to prove, or the prosecution has to prove, that his intent was to bully and harass them, taint the jury pool, all of these reasons that he's giving.
Yeah.
So it seems like it'll be difficult because Turtleboy usually says what his intent is, which is he wants justice for John O'Keefe, and he wants the people who actually killed him to, they're also arguing that what Turtleboy was doing was petitioning the government. And I don't disagree with that. He has a really loud, vivacious way of doing it.
Yeah, for sure.
I wouldn't want to piss Turtleboy off.
No, for sure.
Right?
Yeah.
So anyway.
Yeah, no, he's very resourceful in that respect.
Contextual. You take one sentence out of a 2-hour statement and say that shows his intent. Context matters. Okay, if you're petitioning, if you're protesting, and you say, I want to influence the public opinion in that context, is that trying to intimidate a witness? Or is that trying to bring justice and awareness to what you think is invalid prosecution of someone else?
Let me add something on that. Michael, Mark and I know from close to 20 years of collective prosecutorial experience that what they did in the grand jury was highly suspect, unprecedented. You don't rename evidence and you don't cherry pick evidence. The Odell case, which talks about misconduct and misleading the grand jury, talks about presenting an incomplete picture of things. And that's exactly what they did here, taking, what was it, 58 seconds?
They took 58
2
seconds.
hours.
And the problem is, and this was said in court, but when the testimony is
58 seconds of like a 2-hour video.
Yeah.
I have a video from a folder named intent, and it is named that. That's the evidence the grand jury hears. There is no actual evidence of a folder named intent. That was created by them. Okay, that's not real evidence. That is their editorial commenting on what we believe the actual evidence is, and you're only going to see 58 seconds of it, but not even have access to the rest. And the one question that everyone should ask themselves when you think about this is, there are how many counts of picketing? Okay, the entire rolling rally is on a video that they cherry picked 58 seconds. Again, any prosecutor would tell you, if I have a video of the crime, play it and sit down and say, ladies and gentlemen of the grand jury, here it is. Instead, when you ask Detective Tully, it's from an intent folder and the video is renamed, whether it's by him or someone else, and you don't tell the grand jury that you have evidence of the rolling rally. Why would you do that? What prosecutor would ever choose hearsay evidence and improper opinion evidence other than the best possible evidence you could ever have of any crime, which is simply hitting play on a video and saying, here's what he did. And the answer is because they don't want you to see that. They don't want you to see what's protesting, what is news gathering, what is drawing attention, what is petitioning the government.
His true intent. All those statements of his true intent
That's
that
right.
were omitted.
And if a grand jury determines that we still think there was an intent to intimidate witnesses, then you have to live with that, and there's an indictment. But you can't rig the process. This process was rigged from start to finish. That's all.
Mr. Bederow, do you intend to continue with your request to bring in Ms. Peter, Mr. Tully, and Mr. Mello for an evidentiary hearing before trial?
We asked for it. It's an alternative thing. I mean, look, if there are issues related to that curious relationship and evidence that was provided, we think they ought to answer those questions on their oath. It was very telling in the motion response that we never got an explanation from Mr. Mello. I mean, that is the most obvious affidavit that should be submitted by a prosecutor in response to his alleged misconduct. And that didn't happen here. And the question is why? That's important as far as, civilians who could be part of that process. There are communications that were discussed in court, which are curious, talking about evidence that may or may not have been used in the grand jury. There are, issues as to whether there is personal bias and animus, which is always relevant to a witness's credibility. Nothing could be more relevant to impeaching a witness than showing that they have an actual bias against the person that you're trying to provide evidence with. All of this is important. And, so that was part of our ask, was absolutely for a hearing.
Just one follow-up on that. Mr. Proctor, in some of the release message through Rosemary Scapiccio's motions, said outright that Irish people should die from lack of access to potatoes. Why does that not put your client in the exact same situation as Miles King or any other defendant?
It does, Grant.
I didn't see that one.
We were the OGs of this motion, by the way, guys. We asked for this stuff, 9 months ago? Yeah. 9 months ago, we asked for this stuff, and there's different standards for Aiden, as we all know.
Let me suggest to you, just again, without getting into the stuff about Proctor's racism, neo-Nazism, misogyny, whatever else you want to add to it. Look, he obviously had a personal bias towards him. We can't really speak to that because some of those messages are not publicly available. But we also alleged in a publicly filed motion that he might have taken some liberties when he testified in the grand jury about what he observed during the rolling rally. And again, they used Proctor's testimony, which I would suggest you was not accurate about fact, rather than the actual video. Why would you do that?
Hey, you need to pet that cat.
Oh, I'm petting her. Trust me.
Okay, because she needs that.
And if you have messages in which Michael Proctor is talking about or musing aloud about whether he could ram a pole up someone's rectum and plant evidence in the process, how different is that than possibly lying about what was seen on...
Yes.
Did you say Black Girls for Bradl?
Get in here. Come on,
I mean, it's the rolling rally video is 2 hours long. If imagine a defendant videotaped themselves robbing a bank and they didn't submit that video at their indictment, that tells you everything you need to know about what they consider a crime.
It's worse than that because they did submit 58 seconds of that video and rename it "Don't Feel Sorry for the O'Keefes," and the O'Keefes are not charged alleged victims in the indictment. That's another uncharged crime, just like the wiretapping allegation, put at the very end for the only purpose to be smear him and inflame the passions of the grand jury about this guy says don't feel sorry for the O'Keefes with no context. That is putting your finger on a scale. That is not how prosecutors are supposed to behave, and they know it.
We think that alone should throw this thing out.
To what extent is the Luddite nature of some of the, in this case, somewhat, but in other cases, or the landscape of Massachusetts courts, so this Luddite nature of not understanding the platforms of YouTube, the reach, the purpose, what Twitter is used for, et cetera. You think that's going to play into what the judge and potentially a jury thinks here?
I don't think this judge is there's a concern about his understanding of social media or anything like that, or what YouTube is. I mean, look, people say things on YouTube. Our only point maybe in the back and forth with the judge was that context does matter. And there's no world, I think, in which you're ever going to find any lawyer who's going to say it's okay to cherry pick and then conceal the rest and at least not give the fact finder the opportunity. And people make jokes about grand juries indicting ham sandwiches. The famous Saul Walkler, former judge in the New York Court of Appeals, came up with that statement in the 80s. But grand juries are also designed to stop frivolous or false or improper charges. And there is this muscle memory between lawyers and prosecutors where they think it's an impediment that we have to get through, and it's a joke. This grand jury was treated as a joke by the prosecutors, and it's not. Okay, a grand jury is in the pretrial stage is the last line of defense as a check on the government to make sure that the charges even have cause and are warranted. And it exists. If people don't like it, then get rid of it, like some states have. But it does exist. They have to follow the rules.
If this, one second, let me add. That's a great question. The jurors are not. We don't have a problem with jurors being up to speed on the internet and social media. We look at the jurors' social media as they're coming in the door. We're right there with the computer at trial, looking at their social media, and they all have tons of social media. They're an open book. It's easy to see what they have to say. It's not the jurors. It's the court. The court system has a long way to go, and they view any sort of public scrutiny. I know Aiden's going to agree with this. Any sort of public scrutiny they view as an assault to be avoided somehow, to be the subject of a protective order, to cut off public access. That's sort of a knee-jerk response the court has, but the jurors are great. The court needs some work.
Given the questions around public ops in this case, I'm curious what you make of this idea that when we heard that Tully received clips from a third party and then reinvestigated them, re-looked at them, re-clipped them, re-uploaded them, etc., is that something that we should be questioning?
Of course you should be questioning that. And the problem is Tully said, I don't look at them. I don't click on them because I don't look at third-party things. And then it gets lost and deleted by a third party. And then you get emails a year and a half after specific demands for such emails in which Mello and the third party are talking about. And he says, I can't open this. What do I do? And the third party tells him how to open it. He says, thank you, 2 days before the grand jury starts. So again, I don't know what they did in the grand jury, but I know something stinks here and we need to get to the bottom of it. That's to Grant's question, perhaps why a hearing is necessary.
Do you expect this to be tried here in this courthouse?
Kind of the impression I got when we left here today. It sounds like a Boston trial.
December.
That's what it sounds like. It sounds like jurors, if there is a trial, will be taking a bus ride. But
we'll
again,
come out in the snow.
Did you see Turtleboy's facial expression when that question came up?
No.
Let me go back just like a touch.
that's why a hearing is necessary.
Do you expect this to be tried here in this courthouse?
Kind of the impression I got when we left here today. It sounds like a Boston trial.
Did you see that?
Yeah.
Yeah. So this judge is in Boston, right? And he will have a Norfolk County jury, right?
Yeah. Yeah.
So they'd have to bust them in. And it would be impossible for him to go every day to Boston. So he's going to have to stay in Boston somewhere. And he's going to have to pay for a hotel for his lawyers, not Bradl, because he's local, but Bederow. He's going to have to put him up in a hotel during trial. It's going to be so unbelievably expensive.
Yeah.
I mean, so that's what that face was about.
Yeah.
It'd be cheaper if they could just do it in Norfolk County or, somewhere else without super high, crazy traffic. Because traffic in Boston is nuts.
Right. Yeah, I don't know anything about it.
It's more gridlocked than New York City.
That's what it sounds like. It sounds like jurors, if there is a trial, will be taking a bus ride. But
we'll
again,
come out in the snow, the rain, the cold weather. It doesn't matter. We got your back.
Yeah. So Aiden, I know we don't want this to be a jury trial. We want the judge to perhaps do the right thing and analyze Mr. Bederow's fine argument and come away with the decision that we think is appropriate. However, in the real world, if this goes to a jury, are you anxious to tell that story in full?
Yeah, I'm excited to tell the story in full. I mean, if they want to if they want to relitigate everything that happened and give me the forum to explain why I do what I do and why I did what I did, I'm happy to do that. The fact of the matter is they're hiding my videos. They don't, because on that 2-hour rolling rally, I say my intent over and over again. We are there for justice for John O'Keefe. We are not there to intimidate anyone. If you actually watch the videos, I am under the impression that none of them are even home. How can you intimidate people who aren't even there? I am there to spread the word, to bring awareness to this, and to pressure the government to do the right thing, which is to drop the charges, to avoid quite frankly, the embarrassment. That's what happened to them. They were embarrassed on an international level.
You have to remember, a grand jury is as one-sided as it gets. There's no judge. If you have a prosecutor running amok, as occurred in this case, it makes it worse. There's no cross-examination. There's no defense case. There's no defense argument. In the event that there's a trial here, there will be two parties at the dance, introducing all kinds of other evidence that might be relevant. There's no world in which a trial would occur in this case in which anybody's going to introduce evidence that says, don't feel sorry for the O'Keefes 58 seconds when it's a 2-hour video of saying, how do we get justice for a woman who was wrongfully being prosecuted at the time? And I believe that this officer is corrupt and this and that. All of that will be fair game and will be used, as we argue today, to show context of intent. And it also has to be beyond a reasonable doubt at a trial, not, as they wanted to do here, just rubber stamping a ham sandwich.
Mr. Bradl, any thought that there might be additional proctor material you're going to get your hands on that'll be helpful in this case?
We think there's a lot out there that we're going to be interested in, and that's what we're going to hash out in the next 2 weeks. We're 90% there with Attorney Cosgrove. We don't think that Aiden should be subject to any different rules than every other litigant, and that seems to be what always happens here. Is that there's a whole different standard for when Aiden's involved in a case, and we're going to put a stop to that. We've had it. We want the same protective order that everybody else has, and we expect to get that. And we're going to talk to Attorney Cosgrove, and I think he'll be reasonable on
I
that.
think his response was very practical, given to what it was initially when we asked for this months ago, which was he's not involved in the investigation and he's not going to be a prosecution witness. That ship has sailed. His credibility will be very relevant, and he may not want to be a witness to anything, but he will be a witness in this case, and he'll be called by us.
To be clear, though, does he need to have said, I have prejudice against white Irish guys in their 40s to be considered a problematic investigator in this case?
No, but again, he has a bias, and I can't get into the specifics of what some of those biases are. I mean, some of it's been said before or elsewhere. I'm not going to say it. But if somebody is involved in an investigation and is having communications with other state troopers involved in the investigation, saying things that no one should ever be saying about a target of their investigation, and then it turns out, you see what's going on here, a jury should know about that and should be able to, again, as fact finder, like grand jurors on a lesser scale, use that as part of their analysis to determine, is this investigation credible, or is this a witch hunt? Is this to silence someone who is saying things, by the way, about us? Okay, the reality is the state police should have been conflicted off this case 2.5 years ago. And that's something that never gets discussed. They had no business investigating a case in which a journalist was loudly screaming that you people are corrupt. And as more and more comes out about them, it turns out a lot of people tend to agree with what he said.
What does the sign say right here?
Turtleboy was right.
Coded language. Coded language.
But that's another great question. The idea that you have to have the particular bias is crazy, right? Some people will probably say that. Well, he doesn't. He's okay with Irish people, but anybody that lets their racial biases rather than the evidence drive an investigation, that is fair game for anybody. All right.
Thank you, guys.
Appreciate it. Thank you guys for coming. Appreciate it.
Thank you.
So it looks like it's probably going to go to trial, but I didn't expect anything to come out of the megamotion. So
Yeah.
I mean, I haven't seen a ruling on it yet, but I don't. It seems like these judges I think they described it best when they said they just want to kick the can.
Yeah.
They don't want to be the one to dismiss this case.
No.
They just want a jury to sort it out so they're not responsible.
Right.
Yeah. Okay. You ready to move on?
Yes.